A very warm welcome to everybody who's joined in this webinar on the new labor codes. I am Deepthi. I lead the employment laws practice at the law firm Nishith Desai Associates, and I work out of the Delhi office. I am joined by my colleague Kajol, who works out of the Bangalore office and is a member at the NDA practice in the employment space. So to give you an overview of the way this webinar will move around is that we will first move ahead with introduction of the key changes that have come about in each of these labor codes. And thereafter, we will be discussing the impact that it will have on the employers. Lastly, we will be taking up the questions which you may post in the chat box or the Q&A panel, which is available on the screen. So to give a brief idea about the way the labor codes have come into picture, we'll also bring about the slides. So it'll be more easier for you to understand as to what changes have come in under the labor codes. So as you all may know, the labor codes have come into operation on the 21st of November, 2025. Largely, a lot of sections have been notified. And prior to that, there were certain notifications wherein certain provisions were already in effect. But with the new notification coming in, the impact that is going to be is that now the employers will have to take into consideration the new provisions while they are making any compliances vis-a-vis their employees. Moving on to the next slide, wherein we will take you through the key provisions which have got subsumed into these four codes. As we know that there are 29 central acts which have got subsumed into the four main codes. Now, how this codification has happened is on the basis of functionality. So, for instance, the Code on Wages will have provisions around payouts, such as the Minimum Wages Act, the Payment of Wages Act, the Equal Remuneration Act, and the Bonus Act. Similarly, the provisions around industrial relations have got subsumed into the Industrial Relations Code, which is primarily dealing with positions around a worker and an employer rights vis-a-vis their working conditions. Now, we also have the Code on Social Security, which will take into account all the social security benefits that one has to take into consideration, moving on from the 21st of November. Other than that, there will be certain transition period that the employers will have to be mindful of before starting to comply with the provisions around the SSC. So we do have some bandwidth in terms of time period, which can be factored in while complying with the Social Security Code. The last one is the OSH code, which is also called the OSH code, that takes into account the safety, health, and working conditions of the employees and also certain other rights in terms of duties of the employers, the rights of the employees, and the compliances that the employers have to be mindful of while engaging contract workers. So what is the position as on date? As on date, we know the codes have been notified, which means the substantive provisions of these codes have already come into effect. Now, what do we have to wait for? We need to wait for the rules which are to be notified by the central government. And given that this is a concurrent subject, we'll also have to wait for the state rules to be published. Once these rules come into picture, there will be about a 45-day period, which is going to be a consultation period. Now, once that window closes, it is likely that one will have to start complying with the provisions of these code in full spirit. Now, what happens once these provisions, which have been notified and the compliances in terms of an employer has to undertake? So to clarify that, given that a lot of these are substantive provisions which have already come into force, for instance, the definition of wages, the way a gratuity is to be calculated, one will have to start factoring in the impact of that into their existing policies and framework. Moving on to the next slide, please. There is one particular factor that we wanted to clarify, which is that we do keep hearing a question whether the Shops and Establishment Act will continue to subsist or has that got subsumed. So to answer that, one will have to continue to comply with all the state laws to which the entity is today subject to, including the Shops and Establishment Act, which means if you have provisions around leave encashment, leave entitlement that you are subject to by virtue of the local Shops and Establishment Act, please continue to comply with that. Once we have the rules in place, it is important that the employers are harmonizing their policies so as to align the state rules as well as the rules notified under these codes. The first and foremost is the wage code. Now, what are the legislations which have got subsumed into these? Again, like we said, basis on the functionality, we have the payment of wages, the minimum wages, the payment of bonus, and the Equal Remuneration Act, which have got subsumed into the code on wages. Moving on to the next slide, where we will be taking you through the key changes that have come into the wage code. Now, we have created this slide basis the recent notification. And now when you look at the provisions, largely a lot of these provisions have been notified. So for instance, on the left side, as we see section 1 to 41, and thereafter we have section 42 sub 4 to 42 sub 9. Thereafter we have 46 to 43 to 66, 67, 68, 69 and onwards. So to that extent, when you look on the right side, what are the provisions which have got notified, and therefore one will have to start complying with them with effect from 21st of November. So there's a provision under the Equal Remuneration Act on that there cannot be any discrimination on grounds of gender in terms of pay. That needs to be complied with. And the change that has come into the said section, we will be discussing the same in the slides henceforward. There are provisions around wages, flow wages, hours of work, overtime. There are certain sections, of course, which are dependent on the rules. For instance, what are the flow wages that the authorities will come out with? So one will have to wait and watch as to what are the minimum wages that will be notified basis of flow wages that will be provided by the central government. There are certain other provisions in terms of recovery of advances that you cannot make from the employees. Again, given that the wage code is applicable now to all employees, one will have to be mindful of all of these provisions while moving ahead with any sort of recovery from the employees. Moving on to the next slide, wherein we will be taking up some of the key provisions which have impacted the wage code, which have come into effect via the wage code. So one of the definitions that we need to take into consideration is establishment and employees. So initially, as you would know, the Minimum Wages Act was applicable to a very specific category, which is the scheduled employments. Here, the way the establishment is being defined, it's a sector agnostic definition. And also when we look at the definition of employees, given that the Payment of Wages Act was only limited to employees who drew up to 24,000 per month, now there is no such limit. So in impact, the employees, whether drawing below that limit or above that limit, will be impacted under the wage code. To that extent, the employers have to be mindful of all the provisions which are applicable to employees category or workforce as per the wage code. Another definition that is talked about is the definition of worker. So this has actually been a subject of debate always, even under the Industrial Disputes Act. If you look at the way the term worker is defined, there is a lot of similarity in the definition of the term workman and the way the term worker is defined, except the fact that the monetary ceiling has been revised from 10,000 to 15,000. Now, why this definition is important is that you will see some of the provisions, whether under the wage code or under the OSH code, are applicable only to the worker category of employees, which means that we don't need to only read the definition the way it's provided here. We will continue to have to take into consideration the judicial precedents which you may have applied while determining who classifies as a workman or not. And therefore, even under the new codes, you should continue to interpret the definition in the same manner when you look at the term worker. Now, the third important point that has actually come forth over here is the definition of wages, which we will be discussing in our slides coming forward. There's a 50% ceiling, which one needs to be mindful of while calculating the contributions. Of course, we will be taking you through that in detail in the next slide. Minimum rate of wages, like we stated, it was only applicable to the scheduled industries and employment. Right now, the way it stands, there's a possibility that this needs to be applied to, again, all establishments. Now, one key point that we'd like to bring in here is there were certain states wherein the minimum rate of wages was very low. For instance, the state of Rajasthan had very low minimum wages. So the moment we do have these things coming in, the states will have to take into consideration the floor wage, and accordingly, they'll have to fix the rate of wages. So the impact that the employers will have to take into consideration is what is the minimum wage that has been fixed, and they would have to either revise it and accordingly pass on the benefit to the employees. So one question that keeps coming up is, for instance, what if the floor wage ceiling that is now provided turns out to be lesser than what you're already paying? So to that extent, labor codes do provide some clarity that you cannot make any revision downwards. What you have to rather do is you have to bring up if there is anything that does not match to the minimum wage that has been set out, you have to move that wage, or you'll have to revise it upwards. Again, the last point here on the slide is deductions which may be made from the wages. So the provisions were applicable under the Payment of Wages Act only to certain category of employees who drew only below 24,000. Now, due to removal of that ceiling as such, we'll have to ensure any sort of deductions that you plan to make, whether it is by way of recovery or whether it is any sort of advance that you make to an employee, you have to ensure all your deductions are aligned to it. So what impact it will have is, for instance, there is an HR policy that you do have. You'll have to look into that, and you'll have to see what sort of deductions that are permitted as of now into the handbook. Well, if that is applicable to only particular category of employees, you'll have to ensure now that largely applies to all set of employees in your organization. Moving on to the next slide, please. Right, so time limit for payment of wages. Unlike what the Payment of Wages Act provided, that you'll have to make payment of wages within 2 days, wherein there is a termination, the scope is rather expanded under the new Code on Wages. This is now extended to even positions around resignation. Again, the impact that it will have on the HR payroll processes is that, assuming you are to do a full and final settlement for your employees, on the last working day, the person has actually handed all the equipments, mobiles, internet, laptops, etc., whatever equipments were handed over to the employee. To that extent, as long as there is no full and final settlement remaining, you must pay the amount within the 2 days from the last date. A clarification here is this is not for all the payouts. So for instance, gratuity, you would have a 30-day period. That should continue even under the new code. But for the way the term wages are defined, what you'll have to do is at least the wages are cleared within the 2 days of the separation of that employee, whether that is by way of a termination or that is by way of a separation. The next would be the eligibility of bonus. As you would know, the current ceiling that was there for eligible employees to get bonus was 21,000 per month. So we are yet to see what is the threshold that the rules provide for. But so far as the condition for disqualification of bonus is concerned, sexual harassment has been added as one of the conditions. So for instance, someone has been convicted of the offense of sexual harassment. That will act as one of the conditions for you not to receive a bonus. So to that extent, when you do look at your code of conduct or your HR policies, if you do not have that as a condition, you must amend your HR policy and incorporate provisions around that. Standardization of overtime. So largely what has happened under the code on wages is, given that this is applicable to all sets of employees, the overtime has been extended to all sets of employees, and the rate continues to be double the rate of wages that is payable. Inclusivity of all genders, like we mentioned, the Equal Remuneration Act, which has got subsumed into this legislation, now is also made applicable to the transgender person, which means that while you're extending the payments to your male as well as female employees, you'll also have to consider transgender persons so as to ensure there is no discrimination in terms of recruitment, remuneration, employment conditions for a similar work, and the payout is also similar. Increased penalties. I think this is one of the key positions. Most of you would know that the penalty under the existing labor laws was merely about 100, 200 to 500 rupees. Now that has actually been increased significantly, which means that the effort over here under the new codes is that there should be compliance to that extent, while there is decriminalization of certain offenses, but the focus is clearly on ensuring that the compliances are made by the employers. There's an option of inspector cum facilitator, which means that there will not be simply an inspection, but of course the role has been expanded to ensure that there will be guidance, assistance, so as to ensure that there is necessary enforcement of the provisions under the labor codes. One of the most important points that has been discussed is with respect to compounding. So yes, there is a relief there because this is a provision we would generally see under the Companies Act. Now we are also seeing that kind of a provision moving into the labor codes. Moving on to the next slide, please. All right, so I think this is very critical. Now, why we have just created a diagram like this so as to ensure that we understand the new manner of calculation of wages in a much easier manner. As you would see, there is a component of wages into this diagram. Then there is an expressly excluded components for the purposes of calculation of wages. That second component is the one wherein one will have to ensure it does not exceed 50%. Where it does exceed 50%, you have to add it to the first component. The last component is other cost incurred by the employer. What could be that other cost incurred by the employer? So there is a gratuity or a severance compensation that you are required to pay towards the end of the service. So to that extent, the idea that is behind this definition is you need not take those components into consideration when you do this calculation. So to explain this more clearly, we'll move on to the next slide where we've put these definitions into a clear bucket. Could we please move on to the next slide? Right, so the first bucket is wages means all remuneration. The way the definition stands today is it means all remuneration and emoluments, whether paid by way of an express or an implied condition. And what it further goes on to say is and includes. Therefore, it's an inclusive definition. By virtue of including 3 specific components, it does not mean you will not include other components which you are paying by virtue of the employment conditions. So therefore, one will have to be mindful of what falls in the first bucket. Exclusions are limited. When we look at the exclusions, section 2Y, A to I are specifically dealing with what you need not consider when you do the calculation, which means please don't take into consideration the statutory bonus or the value of house accommodation, PF, sums which is paid to defray expenses, HRA, commission, overtime, allowance. Now, when we look at the second bucket, what is this 50% cap? The 50% cap is for the second bucket, which is where any payments exceed 50% of the amount specified in A to I. That is where you will have to add back that amount to the first bucket so as to arrive at the base amount for the purposes of the calculation of gratuity or other social security contributions. The last one, which is gratuity retrenchment, are specifically excluded for the purpose of this 50% calculation that is provided under J and K. We've also set out an example. Moving on to the next slide, please. So here, as you may see, basic, dearness allowance and retaining allowance turns out to be 49. And the excluded component, HRA, conveyance and commission, turns out to be 50. What we need to do is we need to add back that 1,000 to the first component. A question is whether you need to change the CTC, not necessarily. As long as you're within the particular threshold that is provided when you do that payment or calculation, it is absolutely fine for you to continue the way it is. But then it could obviously become a little hectic for every time for you to undertake that sort of a calculation. So therefore, the preference is always to move to a simpler structure. Thank you. So I'll pass on the baton to my colleague Kajol, who will take you through the SS code provisions and the changes that have come in.
Thanks, Deepthi. Good evening, everyone. So as part of our discourse on the labor codes today, I will be taking you through the Social Security Code. The Code on Social Security 2020 essentially, has consolidated a set of 9 legislations, primary of them being the Employee State Insurance Act, the Employees Provident Fund Act, Payment of Gratuity, Maternity Benefit, etc. And the idea behind this consolidation is to kind of provide for provisions around social security, welfares, and benefits into a single comprehensive framework. So when we talk about essentially what has come into force by the notification on the 21st of November, as we know, there were a series of notifications that were released on the 21st of November. As part of that, under the Social Security Code, there were several provisions that had come into force. Some of them we have listed here as well. These primarily, again, relate to your provisions around definitions, registrations, social security for unorganized workers, gig workers, etc., who have now found mention within the Social Security Code. There are also, of course, provisions around gratuity, maternity benefit, etc. We could now go on to the next slide. All right. So as part of the first set of codes that we had discussed, the wage code, Deepthi had mentioned how there is now a comprehensive definition of wages that has been provided. What effectively that means, there are certain components under what would constitute wages under the wage code, and that essentially will have an impact in terms of how even social security contributions, etc., would be looked at. In that sense, the Social Security Code also uses that simplified definition of wages, and therefore this will have an impact on all your contribution related calculations when it comes to the PF, your ESI, as well as gratuity calculations, etc. So the idea behind this is, unlike previously, what used to happen under the erstwhile laws would be there would be separate provisions on how to compute those specific benefits. For example, for gratuity, it would be say basic plus DA, and that would vary across different legislations. However, now there's one single definition that provides for how each of these components would be computed. So herein we'll just talk about some of the key provisions in terms of what has been brought into force by the Social Security Code. One important factor of them being the fixed-term employment. Now, as such, fixed-term employment did find some mention under the Standing Orders Act, especially the model standing orders under that Standing Orders Act. But as such, it was not really recognized under the other legislations. However, with the enforcement of the Social Security Code, now there is a specific introduction to the concept of fixed-term employment. And the Social Security Code herein goes on to provide these social security benefits to these employees who are now employed on a fixed term employment basis. What that essentially means is that employees who may have a fixed term tenure, the employment would be basis such an arrangement. Those individuals now would also be eligible for social security benefits. I think this is something that's really talked about in terms of their entitlement to gratuity. Yes, these individuals will now also be eligible for gratuity on completion of a minimum of 1 year period. And in that sense, their entitlement to gratuity would be on a pro rata basis. However, we'd like to clarify that while there is a revision to that extent when it comes to fixed term employment employees, The entitlement when it comes to gratuity for permanent employees, that is those who would have been employed on a indefinite period, those individuals will continue to have the eligibility criteria as existed previously under the Payment of Gratuity Act. Now, to also discuss a little bit about the ESI contributions and the payments with respect to that. Previously, what happened in the erstwhile law was that, the coverage would be limited to certain notified areas. And as such, even where, say, there were employees lesser than 10 employees, which also was a threshold in the previous act. However, if there were instances of them not meeting that threshold, they were categorically excluded. However, what's changed now under the Social Security Code is A, this has been made applicable to establishments. B, even when it comes to hazardous or life-threatening occupations, where even there's a single employee who may be engaged, a single worker who may be engaged in such work, they would be entitled, they would be covered under the ESI provisions of the Social Security Code. To talk about the platform worker, gig workers, etc., this is something there's been a lot of chatter around that, and given that these sort of arrangements have now been on the rise, the legislation now actually recognizes these sets of workers and have provided for definitions around who would qualify as a platform worker, gig workers, and they've in fact also defined aggregators who essentially would be your digital platforms, etc., who would be engaging with these individuals. Now, the idea behind this, recognition is that herein, in terms of Social Security, the aggregators are required to contribute about 1 to 2% of the annual turnover, which is capped at 5% of the amount which is paid or payable to the gig or platform worker. In terms of the provisions around Provident Fund as well as ESI, it is important to note that there is a transition period that the legislation in itself provides. This is set at 1 year. So for a period of 1 year from the enforcement of these codes, the schemes around PF and ESI would continue to subsist. While we talk about creche facility as well, so the Social Security Code, while has subsumed the Maternity Benefit Act, it was also stipulated categorically the requirement for employees, the establishments with employees of 50 or more to provide them with creche facility. Now, this is something again which existed in the previous legislation as well. However, what is different from the erstwhile legislation is that there is now flexibility around tying up, with third parties and providing common creche facilities. Herein, this is not something that previously existed. And just to take a step back, there were, of course, certain state shops acts, such as the Maharashtra Shops Act, that do provide for such a provision. They talk about common creche facilities. However, at the federal level, something like this, a flexibility such as this did not exist. And the Social Security Code now going forward provides for the same. We'll move on to the next slide now, please. Now, some of the other elements we talked about, provisions of Social Security to unorganized workers, gig workers, etc. So the Social Security Code, once again, has provisions around providing, the authority to the appropriate government to provide for certain schemes for these set of employees, these set of workers. So the appropriate government, therefore, may come up with schemes for these sets of individuals. However, this is still in the works. This is just a provision that authorizes the appropriate government, and it's not come into force as yet, the schemes in itself. Like we discussed on the wages component as well, given that there is now a standard definition of wages, this of course has an impact on going forward how we calculate aspects around Social Security, like gratuity, provident fund, pensions, etc. Now those would be derived by the uniform definitions of wages that is being provided under the wage code, and that the other labor codes also take into account. One of the other factors that we have seen is in terms of the increased monetary penalties when it comes to the Social Security Code. I think that's in alignment with all of the other labor codes as well. Given in the erstwhile laws, the penalties, however, were very limited. Now there's been a substantial increase in terms of the monetary penalties, which currently range between 50,000 to about a lakh. And there are also provisions around imprisonment ranging from 2 months to 3 years, depending on the nature of the offenses committed. We'll go on to the next slide, please. Now, as we said, there is, of course, because of the change in definition of wages, there is going to be likely an impact on the gratuity as well. Now, for our audience's reference, herein we've just kind of captured a small example. In this situation, our individual is an employee who has about a 10-year tenure, and his basic and DA annually is about 4 lakhs. While the other components that make up his CTC about 6 lakhs. So on the left part of the table, you'll see under the old regime, the computation, which is basic plus DA in this example, would be done on the 4 lakh annually, which comes out to be about 33,334 monthly. So it's on this amount that the individual would be getting the individual's gratuity would be computed on, which comes out to be about 1,92,311. Now, in the same example, what's going to change is given, like we said, their basic plus DA accounts for about 4 lakhs, while the other components are at 6 lakhs. Given that these components are in fact higher than the basic plus DA component itself, the excess in this case, which is about a lakh, will now be added back given the provisions around how to compute wages. Now, what that will have an impact on is essentially instead of the computation being on 4 lakh divided by the monthly, it would now be on 5 lakh instead, with the 1 lakh excess being added into this amount. So essentially what that changes is the monthly goes up by about almost 1,000 and therefore 10,000, and therefore the gratuity component in itself that this individual would now be entitled to under the new regime is about 2,40,386 in our example. So you see, there would likely be an impact on gratuity as well, depending on how the components of CTC are structured. That said, it's important for our audience to note that the gratuity amounts in terms of the maximum threshold continues to be the same 20 lakhs which previously existed under the Payment of Gratuity Act. So that's not changed as yet, and therefore any amounts in excess of this would be taxable as salary. Please could we move on to the next slide? All right. So we have now provided a brief, in terms of the key position, the other key positions when it comes to the Social Security Code. Some of them, the importantly being now there is a specific, time period that is allocated in terms of initiating PF inquiries and recovery proceedings. That's now set at 5 years. And also interestingly, and as a relief for the employers as well, suo motu reopening of cases has now been done away with. When we talk about the Social Security Fund, this is a specific security fund that needs to be established at the central level and also with the state government as well. The idea behind this is to provide for it to act as a fund to finance schemes around unorganized sectors, unorganized workers, gig and platform workers, which will essentially look to cover certain specific aspects such as the life, disability, health, and old age related benefits. Interestingly, even with respect to accidents that happen during the travel between home and workplace, now these would also be considered to be employment related, and as such, it would be now open for the employees to claim compensation when something like this arises. So there is a revision in that sense under the ESI provisions under the Social Security Code. Something that we spoke about in the first set of slides when it comes to wage code as well. There is now a concept of inspector cum facilitator system that has changed from what previously would be inspectors only. The idea behind this is to offer some sort of support to the employers, and in fact even the employees, for guidance, and also ensure adherence to the provisions of the codes. So there is now also an introduction of an algorithm-driven inspection. So it would no longer be only physical inspections, and the code has now provided for something which would be done at this level as well. One of the other key factors, which again remains fairly uniform across the other labor codes as well, taking the concept of compounding of offenses and bringing it into the labor codes as well. The idea behind this again is to kind of ensure increased compliances and reduced harassment. So in cases of first-time offenses, the non-compliances around that, they can be compoundable to the extent of 50% of the maximum fine, and wherein there are offenses with a fine plus imprisonment provisions, those would be compoundable up to 75% of the maximum fine. I will now ask Deepti to again speak about the OSH code, please.
Thank you, Kajol. So the OSH code, which is the Occupation Safety and Health Working Conditions. Now, what happens with respect to the OSH code? It subsumes 13 central legislations. What are the key legislations which have got subsumed into the OSH code? It's the Factories Act, the Plantations Act, the more important one being the Contract Labor Regulation and Abolition Act. We also have the BOCW. We have the Working Journalists, the Cine Workers Act, etc. Moving on to the next slide, please. One of the key changes that, of course, has happened is there are changes in terms of applicability under the Factories Act. For instance, initially under the Factories Act, it was only applicable wherein you would hire, say 10 employees with the aid of, without the aid of power, and 20 with the aid of power. Now that limit has actually undergone a change to about 20 and 40 respectively. Another key change that we do see is the registration process. So while you would have to take a registration under the Factories Act separately, under the CLRA Act separately, and same for the BOCW and other provisions, now essentially 6 registrations have got subsumed into one single uniform electronic registration. Now that would simply simplify the process. So for instance, there are different applications to be made under one form. It's easier for an employer to move ahead with all of these applications under the single unified electronic registration process. Night shift for working women. So it was prohibited, or rather we would say it was restricted, because there were certain conditions that were provided on a state-to-state basis via the notifications. Now there is a permissibility that is seeped in under the OSH code, but then there are certain safety conditions. Largely, when you would see these safety conditions, they are more or less similar to the safety conditions which have been already provided under the respective Shops Act. But of course, once the state rules are notified, we must look into these conditions so as to ensure that there is necessary alignment wherever we are hiring, women in the night shift. One point to clarify here is largely the OSH Act is applicable to the worker category of workforce. So it is not that it is with respect to all employees that you will have to ensure this compliance. You must ensure these compliance for the worker category of employees. Leave entitlement. So initially, the way it was provided under the Factories Act was for any worker completing about 240 days of work was entitled to leave entitlement. And that was again subject to certain other positions in terms of a pro rata calculation. Now we have that limit reduced to 180 days of work. Again, there is a pro rata calculation provided here. Now, one caveat here is the way this provision reads is, again, this is applicable for worker category under the OSH code. Looking at the contract labor, well, the limit which was provided under the CLRA, the way it stood was 20, but then again, there were certain state-specific amendments, so the limit had already reached 50. Now that limit is also provided under the OSH code, and that is again subject to the core activity condition, which we will be discussing in the slides coming forward. Safety committee was initially only required to be provided wherein you had 1,000+ workers in the factory. The limit is now gone down to where you're having 500+ workers for a factory. But in case you're also engaging in any hazardous occupation, the limit is further down to 250+ of workers. Looking at the canteen provision that is to be provided, the limit initially was 250+. Now we have the same to be 100+ workers. But the way that section again reads is it includes contract laborers. So therefore, when you do that calculation, keep the language in mind when ensuring that there is necessary compliance vis-a-vis the canteen provision that the establishment is required to provide. Largely, the role of inspectors have moved into inspector cum facilitators. So we see the same under the OSH code as well. Free health checkup. Now, as this provision was initially restricted to only hazardous occupation, we have this provision coming in for certain establishments such as factories, docks, mines, etc. What are the other key positions? So formalization through appointment letters. Again, one of the provision which has been talked about, but we would like to clarify over here, the way the section reads again is every employee should be given the appointment letter. So this is not again only specific to worker category. This is for every employee that you engage in an establishment, which is covered under the OSH code. You have to issue the appointment letter. Let's assume the same has not been issued. So what the rule now provides is, now this was the draft rule, that you must provide that within 3 months of those rules coming into force. So we should wait for the final rules to come in, and where an organization has not done so, as per the final rules, these appointment letters should be provided. There are certain specific positions which should be covered in the appointment letter. The format is also going to be provided in the rules itself. Working hours and overtime, like we just clarified, the code fixes the working hours to be 8 hours in a day, 48 hours in a week. Again, there's going to be a lot of interpretation challenge over here because it's that Shops and Establishment Act will continue to apply to all categories of employees which are covered over there. Most of you would know the Shops and Establishment Act does also provide certain exemptions. But again, they do differ from state to state. For instance, the position in Maharashtra may just say that employees in managerial positions are not covered, whereas this other states will have a position around anyone who's holding the position of management is not entitled to the protections provided under the Shops Act. So again, one will have to read through to see how to align the provisions under the Shops Act vis-a-vis the provisions under the OSH code. Those are specifically applicable to the worker category workforce. Interstate migrant worker, again, the definition is expanded to now include the workers who are hired directly or through a contractor. When we look at the working journalist and audiovisual workers, which I think we've not taken into consideration so far, we do have dubbing artists and stunt workers who are also included in the said definition. So there is an expansion at that end. And those working in the media industry must take note of that particular change into consideration. Moving on to the next slide, please. Returns and other compliances, of course, now we have a unified annual return. Now, and there are also certain deemed approval positions which are provided under the OSH code. I'll just take about a minute to discuss on that. So under the Factories Act, there is a very clear deeming provision that has come under Section 3, which is that, an establishment which, let's say, gets covered under the code has to make an application within a period of 60 days. Now, assuming the registrar does not, accept that, does not really provide any confirmation, there is a deeming provision which is provided under the proviso in Section 3 itself. And therefore, that is going to benefit the businesses in terms of the approvals for which initially they were supposed to specifically wait out. Somebody also raised a question on what will be the impact of M&A activity. Well, when you do look at the provisions under the OSH code, there is again an intimation that we do see under the provisions which states where there is an ownership in management or, otherwise, if there is a change in ownership, you need to intimate within 30 days to the registrar, and the registrar is to take note. Unlike the Factories Act, wherein, the provision was that you must notify and there has to be like a specific approval provided. We do see that this is specifically helpful for M&A positions, wherein we see only an intimation-based regime in some of the sections seeping in. Compounding, again, one of the most beneficial provision which has been introduced. Moving on to the next slide, please. So keeping in mind the time that we have in hand, I'll quickly run through the core and the non-core activities positions that have come in. So what was the position under the CLRA? You could engage workers via contract laborers. There was no specific identification as to core activity, non-core activity. Well, largely there was an understanding you would not be hiring any worker via contract labor for activities that you would do for an organization. Now that finds its specific place under the definition of a core activity. So there is a clear prohibition under section 57 of the OSH code that you cannot engage a contract labor for the core activities. Subject to the exceptions which are stated on the screen, that is where the normal functioning is as such that it could have been done via contractors, or there was a work which is probably on account of sudden increase, or the third category over here being that the activities are such that they do not require full-time workers for the major portion of the working hours in a day or longer periods. Non-core activities clearly specified in the code would be sanitation, canteen, transportation workers, unless your organization is as such which is set up for these activities. So that also needs to be read carefully. What is the impact? Of course, there will be certain workforce that the employers engage via these contract workers. Please assess whether there is this prohibition which comes to hit the organization workforce the way it is engaged currently. Also, if one is to take protection under the fact that, okay, the normal functioning is as such that the activity is done via contractors, again, there has to be necessary back-end documentation to substantiate that factor. So depending upon the work models that you have, depending upon the nature of industry that you do have, one will have to take into account whether to continue engaging contract workers the way you have been engaging in the past under the CLRA structure. Moving on to the next slide, please. Of course, one point which we did not mention was there's a specific exemption that finds its place under the non-core activity, that is where the work is of intermittent nature. We do see there was clarification provided as to what would constitute work of an intermittent nature, which is something which is done for a period of less than 120 days in a year. One will have to see if that kind of a clarification comes under the OSH code so as to completely understand whether we are compliant with the core activity position that's provided. So I'll again pass on the baton to my colleague Kajol. We are cognizant of the time. We have 9 minutes. We'll try and take you through the IR code quickly so we can also pick up some questions.
Sure. Thanks once again, Deepti. So in terms of the IR code, essentially, again, we're looking at, the legislation which has subsumed about 3 central legislations, the Industrial Disputes Act, the Standing Orders Act, as well as the Trade Union. We could move on to the next slide, please. Again, with respect to the key positions when it comes to this code, there is now a widening of definition around industry as well as worker. Now, industry is now defined to be a systematic activity which is carried on by the collaboration between an employer and a worker, regardless of whether capital is invested or profit is intended. So in that sense, the likelihood of entities which undertake activities for a non-profit or on low capital activities basis as well would likely now be covered under the ambit of industry. Similarly, the definition of worker, which previously under, say, the Industrial Disputes Act was referred to as workman, that terminology has now changed to worker. And the definition itself also has been expanded to now include sales promotion employees as well as working journalists. Additionally, when it comes to the supervisory employees, the wage threshold therein has also increased to up to 18,000. We have to be mindful that the wage threshold that is mentioned here is slightly different from, say, under the wage code, where it is set at 15,000. Under the Industrial Relations Code, the same is provided for to be 18,000. Now, again, one of the recurring factor across all the labor codes, the fact that the wages definition has changed. This will also, of course, have an impact on the computation of retrenchment compensation itself for the set of eligible employees who at the point in time are retrenched. We also see a specific recognition to trade unions as well. Now, under the code, what has happened is, unions with 51% membership in an establishment are now would be identified to be a negotiating union. And what that would mean for this union is that they would have exclusive rights to represent the workers when it comes to grievance redressals or in terms of the collective bargaining arrangements. There's also a concept of negotiating council, wherein they may not, qualify to be a negotiating union. However, the representatives of this trade union would have at least 20% membership is when one would qualify to be a negotiating council. Looking at the provisions around strikes and lockouts as well, what previously was the case under the erstwhile legislation was that the prohibition only was existed, limited to the public utility service. However, this prohibition itself, the exclusion to that end has been, removed, and as such, the prohibition is now applicable to all. Further, the notice period that was period that was provided under the provision previously was about 42 days. Now, under the IR code, that has now changed to about 60 days. Interestingly, one other factor that finds mention in terms of what would be qualifying as a strike would be a mass casual leave. So, where there are instances of mass casual leave, there's a likelihood of those also falling within the domain of strikes. We'll move on to the next slide, please. So in terms of the dispute resolution mechanism that is now being provided under the Industrial Relations Code, there is a constitution of industrial tribunals as well as the national industrial tribunals, which need to be established, and the membership of those would be about 2 members, a judicial and an administrative member. Again, this is still in the works at the moment, while there are provisions around the constitution who would now, and these tribunals essentially would be the appropriate authority for resolving or addressing any industrial disputes. They are yet to be formulated, and these are they currently are only in the form of substantive provisions under the labor codes. Similarly, when we talk about, the easier access to these tribunals, now, unlike what used to happen previously under the Industrial Disputes Act, there are provisions for now parties to directly refer the matters, to the tribunal in case of failure of conciliation. Just to quickly, talk about what used to previously happen was it was, dependent on a reference to be made by the government to the labor code. However, that has been done away with at the moment under the Industrial Relations Code. Also, when it comes to the entire adjudication process, there would be a transfer of all the pending codes from the commencement of the Industrial Relations Code onto the relevant tribunal and the National Industrial Tribunal. Of course, this would yet to be given the fact that the tribunal itself are pending establishment and constitution. We'll also, one key factor under the Industrial Relations Code is the concept of worker reskilling fund. Now this is an additional kind of a component that we have to be mindful for, because the IR code essentially allows the appropriate government to set up a fund such as this, with the idea behind which is to provide for some sort of support and the ability for a worker who has been retrenched to upgrade their skills. The component as it stands currently under the code is about 15 days last drawn wages, and this amount needs to be paid to the worker within 45 days of retrenchment. So as an employer, once this is formulated, this is something which would be an additional cost that one will have to consider beyond the retrenchment compensation that we previously have been seeing. We'll move on to the next slide. So just to quickly talk about the thresholds that have also seen a revision. Now, in terms of the layoff and related provisions when it comes to certain specific industrial establishments such as factories, etc., those from the previous threshold of 100 has now been increased to 300 workers. And establishments who now fall under this threshold would be the ones who would require prior government permission prior to undertaking any sort of retrenchments. Similarly, we have seen a grievance redressal committee being formed, the need for the GRC to be formulated. Once again, this is something that existed previously as well. However, there were provisions around, an alternate redressal mechanism. With the IR code, that provision in itself has been done away with. And when it comes to establishments with about 20 or more workers, there is now a mandatory requirement for the establishments to formulate a GRC with an adequate representation of women basis their presence in the workforce. So that's something that employers will need to be watchful of. Again, talking about the standing orders, provisions, similarly, there has been a revision in terms of the threshold. What previously was about 100, again, subject to state amendments, this has now been stipulated to be about 300 or more workers. Talking about the penalty provisions as well, across the labor codes, there has been increase in the penalties, financial penalties, and this finds mention here as well, where the penalty provisions range from about 10,000 to about 2 lakhs, 20 lakhs. And there are, of course, imprisonment related provisions depending on the nature of the offense committed. We'll move on to the next slide, please. So to quickly talk about the action items for employers and as for our audience, we want to just lay out certain key things that you'll have to look at. Basis the labor codes coming to picture, there is of course a need to review the employment contracts and the HR policies. As such, not just the employment contracts, there's also a need to assess your contracts with in sense of say contract labor, etc. that you will be, for example, engaging. Those are essentially the workforce arrangement in itself will need to be assessed by the employers. With the new definition of wages coming in as well, there would be a requirement to reassess the salary structures, given that there may be changes around computation of each of the payments and the social security contributions, etc. Further, as and when it completely comes into picture, once it's operational, there would be requirements to update working hours, leaves, etc. And in that sense, the HR policies where the employers would need to provide for these very specifically. The idea, again, we spoke about the contract labor provisions as well, and in terms of what may or may not be undertaken as by way of contract labor. So those aspects are also something that we'll need to kind of look out for. And to also ensure digital compliances, given that each of the labor codes have specifically provided for it. So those are things that we will have to be kind of mindful of going forward.
Thanks, Kajol. We do have some questions. We understand there is a paucity of time, but we'll try and take up as many questions as possible. One of the questions is, will consultants or retainers also fall under the gratuity applicability? Well, to answer that, the provision which has been extended is to fixed term employees. Therefore, consultants and retainers will not be entitled to gratuity. Also, to clarify, the provision with respect to gratuity for the employees who do not have any fixed particular term continues to remain the same, which is 5 year of continuous service. Another question that we see is, if the company follows a CTC structure and all components, including gratuity, employer PF, ESIC form part of CTC, can the same CTC be maintained? Well, yes, we don't need to amend the CTC structure. What we have to take into consideration is whether you are complying with the definition of wages for payouts vis-a-vis your contribution. So whether it is your gratuity, whether it is your, other calculations in terms of a social security contribution, whether you're taking that definition for the purposes of payouts is what one have to be mindful of. Again, one question that we see is there a cap on the number of privileged leaves? Yes, it is the OSH code which does put a provision around that the leaves which have been accrued to the account of the worker cannot exceed 30. But again, now this provision is only applicable to the worker category. So it does not extend to the employee category under the OSH code. So therefore, you'll have to align so as to ensure that this provision is complied with while for the worker category, but however, you could continue to comply with your social S&D provisions, which is the shops and establishment provisions, for the other category of employees. Also, there is a provision for the employers to pay out any leave which go beyond the 30-day period, which have been accrued beyond the 30-day, privilege leave bucket. So to that extent, of course, we do find a position under the OSH code wherein one will have to pay that out, and the employer may have to assess the impact of such a payout towards the end of the calendar year. One point that we do find reference to is the term calendar year. So again, for the purposes of leaves under the OSH code, use the calendar year and not the financial year. Well, again, I think a question that is being coming is for gratuity. As of date, on 21st of November, since the provision for even gratuity have come into force, so therefore the calculation for any employee who leaves post 21st of November should be done on the new definitions. We're still awaiting if there is a clarification that comes in, but as of now, the impact definitely is there, because unlike previously that you would only take the basic wages, now you'll have to take the new definition of wages into consideration for the said calculation.
Right.
M&A provisions, we did mention, the impact on M&A provisions. Of course, you can take into consideration the provisions wherein there is only a requirement of intimation rather than an approval process, such as even for the Factories Act, there's only now an intimation process.
Now, just taking up a few more questions, we see that there's a question around gratuity applicability for regular full-time employees as well, whether that would be 1 year. That would not be the case. This is something that's limited to, fixed-term employment employees only. And for all the regular employees, the threshold, the eligibility criteria continues to be the same, which is about 5 years. Separately, we've also seen questions around whether consultants would now be considered to be FTEs. Now, those are separate arrangements itself. The contractor consultant arrangement is something that's governed by the contract itself, whereas the fixed term employment essentially is a subset of an employment arrangement. The idea behind that being, the arrangement itself is for a shorter period of time. To also look at certain questions around the reskilling fund, we understand somebody's asked whether it will be mandatory for employers to contribute 15 days wages into the reskilling fund. Well, yes, currently the provision does provide for this. However, the provision also states that there may be a revision in terms of how the calculation may be made. And as such, at this given point in time, there may not be any obligation that arises, given that this fund in itself is also being set up, and the appropriate authorities would be coming out with the rules around the same.
I think one more question that we do see is whether the employees in the IT industry would qualify as workers. Well, just to clarify, worker does not necessarily mean a person who's working in the manufacturing sector. You will have to continue assessing the way the term is defined under the OSH code. And like we said, there is a similarity in the way it is defined under the ID Act as well as the OSH code. Therefore, you could continue to rely on similar principles to understand whether a person falls under the category of worker or not. Now, whether that is IT industry or not, that does not matter. So that is something that needs to be kept in mind. Well, I think we will definitely try to respond to the other questions on email, and we would request if some of the questions which have got unanswered could be sent to us via our email, and we'll try as much possible to send out the responses one-on-one to all the concerned. We hope you found this webinar helpful. We will continue to provide updates by way of written, hotlines that NDA keeps writing, and we will also notify as and when the rules are out, so the interpretation can be followed the way that's come out. Thank you so much, everyone.